So this is Alexander, Mini Alexanders versus Alexander.
Erica Childs, and today we're here on the motion to quash for Rosalind Alexander Kasparek.
Thank you.
Kelechi Ohanu on behalf of the plaintiffs, Your Honor.
Okay. Your motion was filed on March 9th, 2025. So what's your complaint about how service was effectuated?
Yes, Your Honor, service actually wasn't effectuated on specifically on the 14th. My client was in Houston with other family members, Your Honor. Um, the return filed in the case states that she was personally served in Austin at 5908 South Highway 183. However, on that day, and actually the day prior to, but on that particular day, she was in Houston at University of Houston in the morning for in particular, Afro-American Historical and Genealogical Society meeting in which the family was there for the discussion of a movie or a documentary called High Horse. So she was actually on the U of H campus that morning, Your Honor. Later that evening, she was at a fundraiser for the Links Incorporated, which was the Houston chapter's Boots and Bling fundraiser. The return specifically states that she was personally served. She was not. And I reviewed the file. There's no substituted service.
All right. So what I've got is you telling me she went there, and I've got a sworn affidavit from.
This hearing has quickly turned into a credibility battle. On one side is a sworn statement from the process server claiming he personally served the defendant. On the other is the defendant insisting she wasn't even in the same city that day. The judge makes it clear that arguments alone aren't enough if someone is accusing a sworn process server of being wrong. The court wants live testimony before making that decision.
From a process server.
Yes, Your Honor. She's actually here. We could put her on the record. Also, we do have pictures if you'd like for me to show, but she is actually present, Your Honor. So I can call her as a witness. And while I'm requesting is that the court order them to, and I believe we do have her affidavit on there as well, but I would request.
Your motion is 2 pages long, 3 pages long. So I don't think so. Let me hear from your opposing counsel.
Yes, Your Honor. So we have, like you said, Matthew Stubfield of ATX Processing, who swore on the statement that he not only served the defendant with the citation and the petition, but I called Matthew the day that I received this motion, and he confirmed to me to support his signed statement that he not only served the defendant, but explained to her what the documents were, confirmed her name and who she was, and properly served her. So I reject the opposing party's claim that she wasn't there without any affidavit attached to her motion.
Well, I guess it seems to me you'd need to have him here to testify. I could get them both to testify. This all happened within a few months ago. Even if I granted the motion, okay, we're just going to get her served.
Yes, Your Honor. We did want to point out to the court, however, that the affidavit was that his service return was untrue. And we did want to categorically have it on the record, Your Honor, that Ms. Kasparek.
Okay. Are you want to get him the process server here? Because that's the only way I'm going to be able to do that is have both these people testify.
Yes, Your Honor.
And which I'll do. I'm going to make y'all wait to take up the other people because frankly, so sir, you're going to have to get your process server here. And
unfortunately, he wasn't available at this date, Your Honor, but I mean, I'd be happy to have him return at a later date if we want to reconvene this.
Well, I'm here today. Y'all can ask for a continuance.
I understand, Your Honor. I figured the sworn statement was enough.
Well, but now
I mean, my problem is the opposing party doesn't even have a sworn affidavit to at least contest what my the process server has sworn to admit. So I just think that's a little wonky.
Well, you know, frankly, the whole thing's a little wonky because I can have her testify, and if you're a process server in here, I might find it, and then I'm just gonna say, serve her again. Why are we doing this?
I just have to contest the motion, Your Honor.
Well,
I have,
we,
Okay, well, then okay, I'll take the testimony, but you know, you can cross-examine her, but I'm gonna limit y'all to 30 minutes. I'm not, you know, this was announced for 30 minutes, and so we're gonna
Okay.
say you started at 2:48. So, Ms. Childs, if you want to call your client.
yes, Your Honor, if it pleases the court, I would like to call movant Miss Rosalind Alexander Kasparic.
Ms. Alexander Kasparic, if you would, there you go. Would you raise your right hand to be sworn? You solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. You're muted, ma'am. I can't hear you.
I do, Your Honor.
Thank you. All right, Ms. Childs, you can proceed.
Thank you, Your Honor. Ms. Alexander Kasparic, would you please state your full name for the record?
My name is Rosalind Alexander Kasparic,
And where do you reside?
5908 Highway 183 South, Austin, Building 2, Austin, Texas, 78744.
And on the date of February 14th, 2026, where were you located? Were you in the city of Austin?
No, I was not. I was in the city of Houston for the aforementioned genealogical conference at the University of Houston, which began at 9:30 in the morning. I was driving there from 4 in the morning. Thereafter, shortly thereafter, after that conference, attended Boots and Bling, a fundraiser gala that you mentioned. There were literally hundreds of people at the latter event to attest to my presence. There were approximately 50 or 60 folks at the previous event.
The defense is trying to strengthen the alibi with event information and photos, but the judge immediately stops the presentation. Why? Because evidence has to follow the rules. If exhibits weren't properly filed before the hearing, they generally can't be introduced on the spot. It's a reminder that even strong evidence can be limited if the correct legal procedures aren't followed.
To attest my presence.
And were
No, I'm sorry, go ahead.
And you heard our statements that the process server had filed a service return stating that he had served you at approximately between the hours of 8 a.m. and 9 a.m. in Austin, Texas, off of 183. Is that correct? You heard that?
Yes, ma'am, I did hear that. It is not true. I was not there.
And do you personally know this process server?
No, I do not. I have no idea who it is.
But this process server was hired, of course, by the plaintiffs, correct?
I presume, yes.
And you heard the court asked about the process of why we're here today. Would you please state for the court of why we are here today?
We're here today because I didn't want it on any record or in any documentation anywhere that I had misrepresented my location on the day of the service. I wanted the court to know that it was not me that was being untruthful, but rather whomever said that on a day when I was in Houston among hundreds of people, that they served me personally and explained anything to me about anything. I was not in Austin on the 14th. I was not in Austin on the 15th. I did not even see anything like this service until I arrived home, 5908 Highway 183 South, Building 2, and found it stuck in my door.
And Your Honor, may I please share my screen? Do I have a screen sharing?
Yeah, go. There should be.
Okay. And what do you see on the screen?
I see a portion of the online notification of the genealogy conference at the University of Houston featuring High Horse the Black Cowboy, followed by a debriefing session with High Horse cast. We were not cast in a documentary, but we were present in that documentary of descendant farmers and the series producers. That would have been me, and a digital representation of the producer of the series.
And were any other siblings present that day?
Okay, hold on. Are you going to offer this? Is it in the box? Is it
Um,
marked as an exhibit?
No, it is not currently in the box, Your Honor, but I
Okay, well
can.
then we can't use anything that's not marked in the box as an exhibit, and you can't have the client testify to anything. So
Okay.
if you want to put on evidence, it has to have been in the box. I mean, other than her
Yes, Judge.
testimony.
Yes, Judge. Yes, Judge. Ms. Kasparic, were any other siblings present with you?
Yes, my sister was present with me most of the day prior to the conference, through a short portion of the conference, and certainly in the evening at the Boots and Bling event.
And which sibling was that? Which
I'm
sister?
sorry, it is Winnell Alexander Heron.
And when you have these documentary showings, do you inform your other siblings as well?
Yeah, well, they're public announcements on our website. Sometimes the other siblings are interested. They've all pretty much seen the documentary at this point. These showings are for friends and family. They're designed to share our history and this perspective on Black cowboys that we honor.
And later that evening, which siblings attended the event with you in Houston?
My sibling, Winnell Alexander Heron again, her husband, and several other friends and their friends, and I don't know, there are additional family from the actual family, but certainly us and several friends, close friends.
So what are you requesting that the court do today regarding your motion to quash?
The motion to quash the service is simply because I was not properly served. I feel like the service was misrepresented. I feel that the server's inference that somehow they explained everything to me and I was simply not remembering it or not aware of it or lying about it. I would love that not to be the case that prevails in this particular hearing. It's as simple as that. I don't want to be perceived as someone who lies about a service that I did not receive, that I wasn't even in town to receive.
And so are you asking the court just to order the plaintiffs to serve you properly?
Well, we could do that, but it occurs to me that you've now filed a pleading in her behalf. She's made an appearance in this lawsuit. So I
You're
don't think she needs to be served again because she's voluntarily appeared.
on that, Your Honor, I did research that issue and not necessarily because they still have an obligation to follow all jurisdictional rules. Although a party may have actual notice of a lawsuit, they must go through all the steps and either personally serve her or receive the
I
court
agree, but
permission.
she can make a voluntary appearance, and that's what she's done.
Your Honor, again, I do understand your point, Judge, but my client did want on the record for it to be understood.
That's fine, and we can do an order that says that she was not properly served. However, she is a party to this lawsuit because she voluntarily appeared.
Your Honor, I believe my client would be amenable to that, but she does not want to admit that she's been served and her dates are different because of that. I believe my client wanted to have it. I know my client wanted to have on the record that she was not served because that return is untrue. She was in Houston, Texas on that date. But my client is amenable, Your Honor, if the court wants to issue an order quashing the service and then noting that she has henceforth made an appearance, glad to. And then I, like I did with the other two siblings, will file her response, Judge, her official answer in all of her defenses, Judge. And really, Your Honor, I've had in cases, I had another case where a process server said that somebody had been served and the two of the people had been dead for 5 years, Judge. So I think that it's my client's right to make sure that the court has that information. So.
Of course, it's her right, and I don't have a problem. I get it. But I do believe the case law would say, I mean, if somebody was dead, someone could contest that and show up as a representative of the estate. But here, she has shown up in this court. She's made an appearance. She's participated. So I'll sign an order. You can do an order that says she was not properly served. However, she has voluntarily appeared in this action by your filing a pleading and her coming and testifying today.
We're good with that, Judge. With the court's permission, we'll do that.
Mr. Anu, I do think you ought to talk to your process server. I mean, the only evidence I've got today is that from Ms. Alexander. So,
Understood, Your Honor.
I mean, I once had a hearing where we had to contest service too, and it was, but you got the process server there and you showed him a picture and that wasn't who he served. So I don't, but all right. So Ms. Childs, why don't you draft an order and circulate it?
Yes, Your Honor. Thank you,
All right.
Judge.
Thank you all very much.
Thank you, Your Honor.
Are we
Yeah.
excused, Judge?
In the end, the case took an unexpected turn. Rather than continuing to fight over whether service was valid, the judge ruled that because the defendant voluntarily appeared in court and participated in the case, the lawsuit could move forward anyway. At the same time, the court agreed the service should be quashed and even suggested the plaintiff speak with the process server about what happened. Sometimes, a hearing that begins with one legal issue ends with a completely different solution. If you enjoyed this courtroom breakdown, hit that like button, share your thoughts in the comments, and subscribe for more real courtroom drama and legal analysis.